Folks, the Supreme Court just dropped a brand new decision, and there are two things you need to understand here. The first is what the court actually ruled, and we're absolutely going to walk through that in detail. The second is what's sitting quietly underneath the ruling, the part nobody's saying out loud, but that matters just as much, maybe more, for where this fight is headed. Let's get into it. The case is Wolford versus Lopez, decided June 25th, 2026, and by a vote of 6-3 in an opinion written by Justice Alito, the court struck down what's become known as Hawaii's default rule, or as a lot of people in the gun community have nicknamed it, the vampire rule. Now, this isn't some obscure island-only law. Versions of this same rule exist in California, New Jersey, New York, and Maryland. That's the pattern with gun control in this country. It rarely stays contained. It starts in a handful of states, gets tested, gets refined, and if it survives long enough in court, it spreads outward until it's sitting on the desk of lawmakers in Washington. So what happens in Honolulu was never just going to stay in Honolulu. Let's back up and explain what this rule actually did, because the name makes it sound more mysterious than it is. After the Bruen decision in 2022, the Supreme Court made clear that the Second and 14th Amendments protect an individual's right to carry a firearm outside the home for self-defense. Bruen also preserved something separate and uncontroversial, which is that private property owners get to decide who comes onto their land, guns or no guns. A restaurant, a hotel, an office building, a private home, all of that has always been fair game for an owner to restrict, and nobody serious was ever arguing otherwise. If a business posts a sign saying firearms aren't welcome, that's their right, full stop. The problem is what several states did with that private property principle. Under the old common law default that's existed for centuries, when a business opens its doors to the public, it's understood to be extending an implied invitation to everyone, including people lawfully carrying firearms, unless the business specifically says otherwise. Walk in, shop, eat, do your business, and unless there's a posted sign saying no firearms, you're covered. Hawaii and a handful of other states flipped that default entirely. Instead of welcome unless posted otherwise, the new rule became banned unless the owner specifically, affirmatively, in writing, invites you to carry. That's the flip. That's the vampire rule. Just like the old folklore where a vampire supposedly can't cross your threshold unless invited in, under this law, an armed permit holder legally couldn't walk into an ordinary grocery store or gas station unless the owner had gone out of their way to post a sign inviting them in specifically. Think about what that actually means in practice. Nobody is walking around checking every gas station, every dry cleaner, every hardware store for a sign that says guns are welcome. Nearly no small business owner is going to bother posting that, which means functionally the default became a public carry ban across the vast majority of everyday commercial life in the state. According to figures that came up in the litigation, over 96% of Maui County was effectively off limits to armed carry once you accounted for how this rule operated in the real world. That's not a narrow regulation of a few sensitive spots. That's turning nearly the entire built environment of a county into a no-carry zone through the back door. So how does the court decide whether something like this survives? Bruen set up a two-step framework, and it's worth walking through it clearly because you're going to keep seeing it in every one of these cases going forward. Step 1 asks whether the conduct being regulated is covered by the plain text of the Second Amendment at all. In this case, carrying a firearm for self-defense obviously falls within that text, though it's worth noting that gun control advocates have gotten increasingly creative in arguing that huge swaths of firearm-related activity, purchasing, carrying, even buying ammunition, somehow fall outside constitutional protection entirely. The court wasn't buying that argument here. Once you're past step 1, step 2 shifts the burden onto the government. The state has to show that its modern regulation is consistent with the historical tradition of firearm regulation in this country, meaning it needs a genuine historical analog, not an identical twin, but a real representative example from the nation's history, generally understood to mean the founding era through roughly the Civil War period. And this is where Hawaii's case started to fall apart. One of the state's arguments leaned on the idea that Hawaiian cultural tradition, essentially a spirit of aloha argument, supported treating firearms as something the community simply disfavors having around. Whatever you think about that as a cultural value, the court wasn't willing to let a state invoke a general cultural preference as a substitute for an actual historical legal tradition, and frankly, it shouldn't. You can't take away an enumerated constitutional right by pointing to a vibe. The court's reasoning here draws a clean line. If a right evaporates the moment you cross a state line, it was never really a right. It was a permission slip, granted or withheld, depending on which legislature happens to be in charge that decade. Hawaii also reached for actual historical statutes, and to be fair, the dissenting justices, Kagan, Sotomayor, and Jackson leaned on these too. They pointed to a 1721 Pennsylvania statute, a 1722 New Jersey law, a 1728 Maryland provision, and a 1763 New York law, all of which contain language restricting entry onto another person's land while armed without permission. Read in isolation, that sounds like a direct match for what Hawaii was trying to do. But when you actually dig into the context of these laws, they're anti-poaching statutes. They existed to stop people from sneaking onto someone's farmland or hunting grounds to illegally take game, not to regulate whether a customer could walk into a shop while armed. Comparing a colonial-era poaching law to a modern ban on carrying into a Walmart is comparing two fundamentally different problems that just happen to share a few surface words. Then there's the argument that probably should have never been made at all. Hawaii's side, running low on founding-era support, reached for an 1865 Louisiana statute that barred carrying firearms onto another person's premises without consent. On its face, sure, that looks closer to the modern rule, but 1865 Louisiana wasn't just any random year and place. That's the immediate aftermath of the Civil War, the exact period when Southern states were passing what history remembers as the Black Codes, laws specifically designed to disarm newly freed Black Americans and leave them defenseless against violence and intimidation, while stripping them of any meaningful political power. Leaning on that specific law as historical support for a modern gun regulation is, to put it plainly, leaning on the legal architecture of Reconstruction-era racial oppression to justify a rule that today applies to every citizen in the state. That's not a strong historical analog. That's borrowing from one of the darkest chapters in American legal history and hoping nobody looks too closely at where the citation actually came from. Writing a separate concurrence, Justice Amy Coney Barrett zeroed in on something that deserves its own spotlight. Hawaii, in the course of defending this law, essentially admitted that the underlying motivation was that most residents simply don't like the idea of people carrying firearms around them. Barrett's response was direct. Mere disapproval of constitutionally protected conduct is not a valid basis for restricting or eliminating that right. We settled this principle with the civil rights movement. We settled a version of it a century before that with the Civil War itself. And yet here we are in 2026 still litigating whether popular discomfort with a right is enough to erase it. Apparently for some, that question remains very much alive. So here's the practical fallout. California, New Jersey, Maryland, and New York all passed close variations of this same default rule scheme after Bruin came down. And all four of them are now going to have to go back to the drawing board because the foundation they built these laws on just got kicked out from under them by the nation's highest court. That's not a small ripple. That's a 5-state framework getting dismantled in a single ruling. Now here's the part I promised you at the top, the part that isn't stated outright, but that you can hear if you're paying attention. Look at how the dissenting justices are framing their disagreement, not just in this case, but across the string of post-Bruin rulings. They're increasingly describing the history and tradition test itself as a failed experiment, something unworkable, something that needs to be reconsidered or replaced down the road. Why would they be laying that groundwork? Because they understand, whether or not they say it in so many words, that under this test, as currently applied, they cannot win. If the rules of the game require an actual historical analog, and the courts are taking that requirement seriously, gun control advocates keep losing case after case, state after state. the complaints about the test being broken aren't really about judicial methodology. They're a preview of the next fight, which is going to be about getting rid of the test altogether once the composition of the court changes. That should make everyone paying attention feel two things at once. On one hand, there's real reason for optimism right now. The court has been consistent, methodical, and unwilling to accept manufactured or misapplied history as a substitute for the real thing. On the other hand, this win is not permanent by default. It's permanent only so long as the current approach to the Second Amendment holds at the Supreme Court level, and that depends entirely on who continues to sit on that bench. Rights that depend on court composition are rights that require ongoing vigilance, not a victory lap and a shrug. This is why it matters who you vote for, and I want to be clear. This isn't a partisan hobby horse. This is bigger than a left-right framing. Self-defense is not a red issue or a blue issue. It's a human issue, and the numbers back that up. Data going back through multiple administrations, including figures compiled under the Obama-era CDC, put defensive firearm uses somewhere between roughly 500,000 and several million times a year in the United States. In the moment those situations happen, seconds matter, and a 911 call, however fast the response, simply cannot compress those minutes down to zero. The right being litigated in cases like this isn't abstract. It's the difference between having options in the worst moment of someone's life and not having them. Before we wrap up, if you've made it this far, go ahead and hit that like button and drop your thoughts in the comments. I want to hear what stood out to you, what you think I glossed over, what part of this ruling you think deserves more attention going forward. I read all of it, and I appreciate every bit of the discussion this channel gets to have because of you. Let's close with our quote of the day. This one comes from Justice Robert H. Jackson, writing back in 1943 in a case that was actually cited within this very decision, where he said that the very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy to place them beyond the reach of majorities and officials. Couldn't put it better myself. Things aren't going exactly as some folks in power would like, and that's a good thing. We are winning the war, one ruling at a time. I'll see you in the comments, and I'll see you in the next one. Take care.